Hello, seniors. Welcome to our last video lesson. This is chapter 17. So you should be in chapter 17 in your books. You should have either printed out your copy of the chapter 17 outline, which should be attached to the video, or you can make your own notes, whichever works fine. So chapter 17 will be the last lesson, will be the last test. So no tests on chapter 15, 16, tests on chapter 17, no tests beyond that. So chapter 17 is in the Judiciary, page 385 in your book. So we skipped over to at least talk about this a little bit. Didn't get to take your quizzes on Supreme Court justices, which I'm sure makes you extremely disturbed you didn't get to do that. So we talk about judiciary, we talk about the judicial branch, talk about the law. Law, of course, in the truest form of law comes from God, and God's law is above all human government. Judges are the people who interpret law, and they can impose order even if they reject the law of God. But society is just only in the extent that it does. Human judges do allow scriptural morality to run the game. Okay. So only then is the legal system truly a government of laws and not of men. All right, so it talks about sources of American law on page 385. And basically law and justice themselves are throughout the scripture. God calls men to do justice, especially for those who can't defend themselves. So God's standard for justice is his own character. We talked about that before. So here's your first test question. So what's the definition of justice? Okay, justice is therefore conformity to God's character. That's what justice is. God's character is revealed in the Bible and revealed through the person of Jesus Christ himself. Anything that doesn't conform to God's character is therefore, any law like that would be unjust. So what's the historical foundation for law? So here's another test question for you. So the most famous ancient law materials are those of Hammurabi. He was the king of Babylon and emperor of Mesopotamia, somewhere around the 18th century BC. His document is a collection of legal decisions in trying to formalize law. So there's a question for you. Okay, all right. By the 10th or 11th century, basically Justinian's code was used as a legal basis for problems solved by the Romans in European cities. On page 387 talks about the Middle Ages. Here's two more test questions for you. So during the Middle Ages and the Renaissance, it was only England that was able to hold out against the reception of the corpus juris. Okay, the corpus juris was something used by other countries. We're not going to, that's in the book, we're not going to really talk about that. England went to the common law. Common law, it's a test question on common law, okay? A couple of test questions. So it was common because it was not local feudal law, but common to the whole realm of England. Common means it applies to everybody. Common law was grounded in case law. We talk about case law a bit. Case law is basically what happened in the past. When these things came up in the past, when we were looking for judicial opinions, what was decided, okay? So royal judges who, at least in theory, were following the precedents, that is the authoritative rulings of those who come before them. Case law is still an important way that things are measured today. Well, this was discussed before. How was it decided? If it was decided that way, we should follow that unless we can show some reason why we shouldn't. English common law also encouraged the development of jury trials, which brings us to some more test questions. Like other Western European countries, England took its system to their own colonies, and therefore the English legal system came to the American colonies. Everywhere that English was the native tongue, that was law. So here's your test question. So 10 years before the American Revolution, a guy named William Blackstone, that's in your book, page 388, William Blackstone, he was Oxford's first professor of English law, and he produced basically a handy key to the system of English common law in his book called Commentaries on the Laws of England, which was published in 1765. Even today, Blackstone's commentaries are basically owned by almost any lawyer. This is the idea. Blackstone, according to Blackstone, God expressed his law through both creation that is a natural law that's given to all men. That's what the Apostle Paul referred to in Romans 2:15. And then, of course, here's another test question for you. God's revealed law, that's contained in the Bible. Blackstone said, upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human law should be suffered to contradict these. Makes a lot of sense. Okay. All right. Page 389 has has a table there that says common legal terms, lots of interesting stuff in that. All right, section 2, next major section starts on that page, structure of the courts. We're going to look at judicial federalism. So before the Constitution came into being, each of the new American states had common law courts. And basically, so how these new common law courts would be related, how the state courts would work in addition to the new national courts, that would be an issue the Constitution writers had to deal with very carefully, okay? And so pretty much in the summer 1787, they chose just to not answer that question, worry about it later. They almost certainly understood there would be national courts, and at some level, those would have to exercise review over state courts, but there's no way they could have envisioned the power the Supreme Court has in our society today. Basically, at the end of the 18th century, judges were expected to find the law, enforce the law, not make law, but obviously we've gone beyond that. Another test question for you. You look on page 390. Judiciary branch comes under Article 3 of the Constitution. So Article 3 of the Constitution, basically according to that, federal courts, it's on the book there, federal courts are empowered to hear the following cases: constitutional violations, congressional violation, treaty violations, lawsuits between foreign countries and the United States or between foreign countries and American citizens, cases involving U.S. ambassadors or consuls, cases involving crimes committed at sea aboard American vessels, cases involving crimes committed on federal lands or federal property, and lawsuits between states or citizens of different states. That's the one you hear about the most. Don't forget, guys, on all these tests, you're allowed to use your handy-dandy copy of the Constitution, which if you're not going to keep, I don't care if you keep it, I would like to have it back. I'm not sure how that's going to happen. I have lots of material out there that I'd like to have back, but I'm sure we'll figure out something. All right, so next test question. The United States basically has also become a testing ground for a system of basically federal and state courts, what we call judicial federalism. And basically something that had never been done before. So even today, with the expanding federal powers, state courts are still important. State courts still make a lot of decisions. So let's talk about some other courts. Look on page 391 on your outline, district courts. So some test questions here. So in 1789, Congress passed the Judiciary Act, and that created a system of lower courts, inferior courts. That doesn't mean worse, that just means lower. Inferior courts, and basically got the United States Supreme Court rolling as well. The act created 13 district courts. There's a map there on page 391 that shows you the district. 13 district courts. These would be the trial courts that are as part of the federal judicial system. Remember, the Supreme Court is not a trial court. Today, the United States actually has 94 district courts. District courts exercise what's called original jurisdiction. There's a test question for you. Original jurisdiction. Original means that they are the first to hear a case before any other court hears it. That's called original jurisdiction. But as in most state courts, district courts also use a grand jury. That's another test question for you, to indict or charge accused criminals. Grand juries, they're federal grand juries or local grand juries. So the grand jury is a group of citizens that get together, view things before they come to the court to decide whether it's worth the court's time and the taxpayers' money to view those. And then, of course, they also have petit or trial juries, French, I guess, petit, but a petit or trial jury to hear the case and actually decide on its outcome. President also appoints United States Attorney and a U.S. Marshal for each of those districts. All right, the next section on your outline says Circuit Courts of Appeals. That's the second tier of the federal judicial system, all right? The Judiciary Act of 1789 created 3 circuits. Today, there are actually 12 circuit courts of appeal. 11 plus 1 in the District of Columbia. As the name implies, circuit courts of appeals have appellate jurisdiction. Appellate jurisdiction, that's on page 392. Appellate jurisdiction only. They do not do original jurisdiction. Trials do not start there. They don't hold trials. They listen to appeals from the district courts that are in their circuit and look at what the district judges did and look for errors in procedure or legal interpretation. If they don't see any, then they're not going to do anything. All right, that brings us to our favorite thing, the Supreme Court. So that's the third tier. You have district courts, you have district courts of appeal, and then you have the Supreme Court. That's the most powerful court in the world, actually. You know, other court like that in other countries. At the beginning of our history, of course, it was pretty weak. And therefore, it was hard to get good people to be on it because people knew it was weak. But things would change. Here's your next question. The period of Supreme Court weakness gradually ended after John Marshall became Chief Justice in 1802. Marshall was a brilliant juror, and he basically he attracted a lot of people to come with him. So certainly by 1900, the Supreme Court had become equal in power and prestige to the Congress and the President. Not been true before. All right, next section says justices and their jurisdiction. Supreme Court judges are called justices. Constitution does not require a specific number, and the first Congress appointed 6. Between 1807 and 1869, the number ranged from 7 to 10. Here's your test question. Since 1869, 9 justices, that's 1 Chief Justice and 8 Associate Justices, have composed the Supreme Court. That has not changed. Basically, you might remember from history that President Franklin Roosevelt tried to change that, but that got him in trouble. All right, and remember another test question. I don't think the book quite says this, but remember these justices are appointed for lifetime appointments. They either have to die or resign or be impeached, which hasn't happened. Supreme Court actually can do both original and appellate jurisdiction. However, original jurisdiction is pretty rare. Basically, original jurisdiction would be like the things we mentioned, one state suing another, or cases involving U.S. ambassadors and consuls. And so they do very, very little original jurisdiction. The vast amount of their workload is appellate jurisdiction. Most of the cases, the vast majority, come to the Supreme Court on what's called a writ of certiorari. Okay, from the federal courts and state Supreme Courts. A little weird Latin. Okay. All right. If you look on page 394, jumping around, so whenever okay, so it comes to them, and if the Supreme Court, they get lots of cases come to them, they don't do. But if they accept the case, then the lawyers for each side present written briefs, which explain their positions. A brief is a figure of speech. The briefs are really usually pretty long. As the book says, could be book length. A case is won by a simple majority. There's 9, so that's you only need 5, and we know that from history. Lots of decisions have been made by 5 jurors. Supreme Court sessions begin on the first Monday in October and last through the following June. Basically, if the Chief Justice votes with the majority, then the Chief Justice or someone the Chief Justice assigns writes what's called the majority opinion. If the Chief Justice is in the minority, then the senior justice on the winning side assigns a writing of the opinion. Justices on the losing side frequently use what's called a dissenting opinion. Basically, they're trying to explain why they disagree in the hope that their arguments might be used in the future for some future court to go in their direction. Obviously, there's a picture on page 395 of the Supreme Court Justice. That was in 2003. That's way old. Again, we didn't get to that quiz, unfortunately, but you still ought to know who the Supreme Court Justices are. Again, there's only 9. They're there for a lifetime. It doesn't change very much. You got to see 2 changes during your lifetime, but it's important to know that. So John Roberts is the Chief Justice. We also have the 2 new justices, Neil Gorsuch and Brett Kavanaugh. We have Samuel Alito Jr., Clarence Thomas, and Stephen Breyer, and then the ladies Ruth Bader Ginsburg, the infamous Ruth Bader Ginsburg, Sonia Sotomayor, and Elena Kagan. All right, let's go to page 396 and the selection of judges. Let's look at state judges first. basically, unlike a lot of European systems, to become a judge, you don't need any specific legal training. You don't have to be a lawyer. You don't have to have a legal background. You just got to be elected. Now, having said that, most American judges do have some sort of legal background. And basically, since it's an election position, then that involves some level of involvement in partisan politics. Not required, but that's how you get elected. All right, let's look at federal judges. According to Article 2, Section 2 of the Constitution, the president appoints all federal judges with the approval of the Senate. Like state judges, federal judges usually get there for political reasons. President's going to try to get, you might know that President Trump has got a lot of judicial appointments here in his time. All right, that brings us to the justices of the Supreme Court. Obviously, these are very, very important and rare, so it's difficult to come up with a general rule. But basically, the president generally wants to choose somebody who is in line ideologically with his position, conservative, liberal, whatever. But then obviously it has to be approved by the Senate, and therefore the president might not nominate somebody they really would like to have on the court, knowing that that person is maybe too far in one direction or the other to be approved by the Senate. So there's a little bit of a game play there too. So it is a political thing. All right, so it does have to be confirmed by the Senate. That's called judicial confirmation. And until the past few decades, it was pretty much, okay, the president appointed these people, fine, Senate was no big deal. But in the last few decades, it's become a very, very big politicized process, obviously because the Supreme Court has become a lawmaking body, basically. Before they did that, when they just ruled as the Constitution spelled out, it really didn't matter that much who was on there as long as they knew the law. Now that the Supreme Court is involved in making changes in our society based on their decisions, and obviously the political leanings of those judges, conservative or liberal, whatever, makes a whole lot of difference, especially to the president. And that's why it's becoming a much, much bigger deal, not pickle. So basically, there's a big, as you probably saw it the last couple of years. Even after the Senate confirms the president's nominee, there's no guarantee that the new justice will make any difference. There have been a few presidents who had the bad luck of choosing who they thought was somebody ideologically aligned with them. It turned out they weren't. So basically, a lot can happen over the period of time somebody's in office. All right, Section 4, page 399 is constitutional and legal change. So Chief Justice John Marshall, as we already mentioned, was the guy who turned a weak Supreme Court into a more prestigious and powerful institution. One of the questions that had to be answered at the beginning there was whether each individual branch of the federal government or the individual states, rather than the Supreme Court, might decide when the Constitution had been violated. So, test question. So in Marbury versus Madison, 1803, that's called a landmark decision. These decisions that substantially change the way we do business are called landmark decisions. Marshall basically declared what was called the doctrine of judicial review. Test question there. Judicial review, the right of courts to declare executive and congressional acts unconstitutional, not really in the Constitution. In Marshall's view, it was emphatically the province of the Judicial Department to say what the law is. Okay, so that basically was a little bit of extension of power there. So look on page 400. Marshall was a strong nationalist, so he was very serious about the supremacy clause of the Constitution that said the Constitution and the laws of the United States are the supreme law of the land. Anything in the constitutional laws of any state contrary notwithstanding. So here's your next test question. Another landmark case, McCullough versus Maryland, 1819. The Marshall Court ruled that the state taxation of a second bank in the United States was unconstitutional, even though chartering banks was not a power specifically granted to Congress in the Constitution. There are basically two major schools of Constitution interpretation. Strict constructionism, also called judicial restraint, and broad constructionism, also called judicial activism. Strict constructionists believe that courts should only apply what is clearly laid out in the Constitution. Clear statements in the Constitution make their decisions and should not go into strange interpretation of the Constitution to make social policy. Those who are in favor of broad constructionism feel that it's a role of the court to be a policymaker to interpret the Constitution and meet present needs at times of change. For instance, in Bush versus Gore in 2000, Supreme Court assured the election of George W. Bush by overruling the Florida State Supreme Court on state election law. That would be activism. Obviously, Brown versus the Board of Education. We'll talk about those in just a second. Activism in the Supreme Court obviously ran into issues during the Great Depression. Remember, we talked about that last year, and I mentioned earlier in this discussion when the Supreme Court ruled so much against a lot of Franklin Roosevelt's legislation called unconstitutional. Roosevelt's answer was to try to pack the court with the additional justice. He tried to get the Congress to add 6 and also to put an age limit. The court, of course, was upset about that. But eventually, several justices did retire, and Roosevelt could make his own nomination. But many Americans were shocked by the attempt to mess with the Supreme Court, and that may have affected some of its future voting. Some of the justices named by Roosevelt, remember, lifetime, were still on the court when Dwight Eisenhower selected Earl Warren, former governor of California, to be the Chief Justice in 1953. The Warren Court would become the most influential American court in American history after that of John Marshall. And we talked about judicial activism, so that brings us to test question in Brown versus the Board of Education of Topeka, Kansas, 1953, which basically banned the segregation in schools. Again, not because of legality, because of sociology. Basically, the Warren Court ruled that police, anyway, so that was one. They ruled that, obviously, it was years before it took place. Another example of activism, another test question, the Warren Court also ruled that police could not use evidence seized without a warrant, that suspected criminals must be informed of their rights. That was in Miranda versus Arizona, 1966. You've heard the term Miranda rights. That's where it came from. Another one, another famous judicial activism, another test question was the right of privacy. In Roe v. Wade, 1973, that was the infamous decision that legalized abortion under privacy rights. That was how they interpreted it. That came under right to privacy. And that was a Texas case. Roe, Jane Roe, was a made-up name, not Jane Doe, but Jane Roe. And Ms. Wade was the district attorney for Dallas County. So that was a pretty famous. We're still battling that one even today. All right, so that brings it to an end. That's our little last little lesson here. You'll do your notes on chapter 15, 16. You'll read about that. And then, of course, anything else will also be the same thing. So enjoy, make sure your notes are ready, and talk to you later.